Mr. Manning, are you ready?
Yes, Judge.
Who are you ready on?
We can start with Mr. Villareal.
Sergio Villareal, CR 21373. Will that be a plea today, Mr. Manning?
Yes, Judge, I will.
All right, can you go ahead and walk me through what the terms are?
Absolutely, Judge. He's been pleading to driving while intoxicated, third or more, a third-degree felony. That's going to be upon a plea of guilty, punishment assessed at 5 years, TVCJ, institutional division, EMS trauma fine of $100, $60 restitution, and they're going to take into consideration DA 2020-0429, which is a DWLI with previous conviction. And in addition to that, he has court cost of $290, reimbursement fee of $155, and he has 492 days credit.
Thank you, sir. Mr. Villareal, will you raise your right hand? I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you. You can lower your hand. All right, Mr. Reads, writes, and speaks English.
Judge, we lost you there for a second.
No, hang on. Maybe my microphone. How about now?
We can hear you.
Okay. Sorry, I've got some connections that are not. All right, Mr. Villareal, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
And have you ever been diagnosed with a mental condition?
Yes.
Okay, can you tell me about that?
Bipolar disorder, major depression, anxiety, and insomnia.
Okay. Are you on medication for those or undergoing treatment for those?
Yes, sir.
Okay. Do you feel like you have a rational understanding of the proceedings as they are going on here today?
Yes, sir.
Okay. And you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation?
Yes, Your Honor.
Do you feel like you've had enough time to talk with him about your case and that you've had all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And you're swearing to me that your signature as it appears in the paperwork is your true and correct signature and that you only signed once you understood what you were signing?
Yes, sir.
Mr. Manning, do you believe your client to be competent today?
Yes, Judge.
And you've explained to him his rights as they pertain to this plea agreement and the case?
At length, yes.
And you believe he understands everything?
He does.
All right. Mr. Villareal, you are charged by indictment with a third-degree felony offense of driving while intoxicated, third or more offense. That does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison if you're sentenced. I see that the plea agreement that Mr. Manning has read to the court falls within that legal range of punishment of 2 to 10. Understanding the range of punishment, understanding the plea agreement, you still wish to go forward?
Yes, Your Honor.
All right. Mr. Villareal, how do you plead to driving while intoxicated, third or more offense?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
And has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right. Court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to state's one.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
From the defense?
Rest in peace, Judge.
State, can you give me a summary of the evidence to support the plea?
Yes, Your Honor, on the date in question, the defendant is seen to fail to maintain a single lane. The officer seen signs of recent narcotic use. Defendant agrees to do field sobriety, and then once it's actually time to do the test, refuses. But he consents to a blood test, and the blood test comes back for amphetamine, delta-9 THC, and methamphetamines. This is DWI number 3. And he obviously does not have a license. And that's the 1245.
Thank you, Mr. Manning. Anything further from the defense, Mr. Manning?
Nothing from defense, Judge.
All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Villareal of this offense. The court will follow the plea agreement reached between the defense and the state. Court hereby convicts Sergio Arturo Villareal of driving while intoxicated, a third or more offense, a third-degree felony. Court assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. orders him to pay a $100 fine, $60 restitution, $290 court cost, $150 reimbursement. Court takes into consideration and dismisses DA 2020-429, a driving while license invalid, and the court awards Mr. Villareal 492 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Villareal, you are hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Good luck to you, sir. You'll step over with a deputy and he's going to take your fingerprint.
Judge, I also have a completed paperwork on Ms. Jacqueline Smith, but I don't see that she's been brought in at this time. If you'd like, we can go through some of the other resets.
Sure.
Mr. Gates.
Cody Eugene Gates, CR 21-217. Motion to revoke. Go ahead, Mr. Meany.
Judge, I was just appointed on this case and I spoke to the state. We've reached an agreement to request that he be set on the next available docket for a plea.
All right, court can set him on January 24th at 1:30.
Yeah, they'll take you back. Mr. Dalton Thompson.
Dalton Garrett Thompson, CR 22-50. Motion to revoke. Go ahead, Mr. Meany.
Judge, we also have an agreement on Mr. Thompson. He has the motion to revoke as well as an unfiled case. And we are going to be resolving both of those at the next docket.
Do you want the same docket 124?
Judge, is there one before that? I know that Mr. Thompson's wife is eager for him to be home and help around the house.
Is it what are we doing on the motion to revoke?
My understanding is it's a misdemeanor motion to revoke that's going to be resolved by a time served plea. He's got a bit of time accrued, and so he's going to be getting out time served on both those charges.
The next one I have is the 24th. If that's going to be the recommendation of the state, if y'all wanted to agree to some kind of bond in the interim, I would entertain that. But otherwise, 2 weeks. 2 weeks is the best I can do.
We understand, Judge, and that's obviously not what we agreed to with the state. So we'll just take that date on the 24th.
All right, the court sets Mr. Thompson then for plea on January 24th at 1:30.
Next, Judge, if we can call, we have 2 writ settings. One is Mr. Schmidt's, and one is mine. If we can call those now, I believe they should be pretty short.
All right. Court calls writ WR 23-5. Silas Carter. All right, and Mr. Manning, are you going to call your client to testify for purposes of the writ?
Judge, I don't plan on it. We reached an agreement with the state for a PR bond. We filed that order last Friday, and I was told that we would need to have some type of hearing. I'm not sure for what purposes, but I was told we'd have to have a hearing on that agreed PR bond.
Yes, so as y'all will recall, the magistrates already magistrated Silas under Senate Bill 6, and the magistrate set that bail after reviewing the PSRS, the criminal history. This court is not authorized to review those things at this time, and so I'm not able to adequately review all of the necessary bail factors that SB 6 requires the court to review before changing, modifying, lowering a bail. So if I could hear some things that would satisfy SB 6, then I think I would be able to rule on whether or not the bill should be modified as the magistrate originally said it.
And then I guess I misunderstood that. My understanding was that this court was getting access to the new system, and you already had access to that in order to make those changes.
Not yet. We're in the process. Ms. Tabraham's done her training. I'm trying to get mine completed.
Okay. In that case, we wouldn't oppose the state offering the PC affidavit or whatever in support of.
Y'all want to summarize what it is and put that on the record?
Sure, Judge. Mr. Carter was a part of a group traveling from Mississippi to New Mexico to work on a job in the oil fields. He had been asked to drive by one of his buddies, so they got in the car that he knew to be a rental, but was not rented under his name or his buddy's name. He drove that car on the way to stop to Dallas for the night, and upon being stopped, one of the occupants had a warrant, not Mr. Carter, and that person was arrested, and then Mr. Carter was arrested because the vehicle appeared to be stolen or registered as stolen, which was the reason for the stop. My client had no knowledge of the vehicle being stolen, and that's the reason we're getting a PR bond at this point for the state to develop their case.
Can y'all tell me about criminal history, and then if there's any concern the court should have about Mr. Carter not being able to return to the jurisdiction? I see that he's a Mississippi resident.
That's correct, Judge.
Judge, we don't have a criminal history pulled on Mr. Carter. I will note that he is, as the court can tell, I think he's only 20. Well, Mr. Carter, you're what, 23 years old, 22 years old? I'm trying to do math real fast in my head. We don't have a criminal history. We don't receive criminal histories until we receive cases, and we have not. This also, the date of offense is about a month ago, and we do not yet have a case. If the court wants, the DA's office can pull criminal histories. That's not our general practice. The law enforcement agencies pull those for us. But in cases such as this, we can pull them. It's going to take some time.
No, I understand. Well, I guess this is my concern. So y'all are recommending a $5,000 personal bond, but y'all don't know anything about history or anything either. But y'all are recommending that he just be let out on that.
Based on the affidavits that I've seen, I have serious questions about prosecuting further. I am unaware at this time until we receive more information about whether he will.
And Judge, if it will help allay the concerns of the court, my client has not been arrested for or charged with any violent offenses, nor has he been arrested or convicted of any bond jumping, bail jumping, failure to appear, evading, anything of that matter. So under Senate Bill 6, meeting those criteria, he's not a risk under any of those factors based on my discussions with him about his criminal history.
Okay. All right. The court will approve the recommendation of a $5,000 personal bond for theft of property, $30,000 to $150,000. And the court has signed that order, and I'll have Ms. Tabraham send y'all copies.
Thank you, Judge.
Okay. This lady was taking me today. I
Mhm.
knew nothing about them doing an information yesterday, nor have I been asked about it on the docket, so. That's why she's not on there.
Okay.
Jacqueline.
Jacqueline Smith.
It's CR 23. 00003. They filed an information yesterday.
And it's, looks like it's a state jail felony. Harassment. Of a public servant.
So I told Brian that she wasn't on the jail list, so he said he'll get her, like, I mean,
Okay, oh, I'm sorry, it's attempted. It's gonna be attempted harassment of a public servant. It's an information that they filed yesterday.
he needs conviction
Yes.
before he gets that.
You're talking about Silas Carter? Yes, oh yeah, so. I'll write that at the bottom of this. All right, Mr. Manning, are you ready? Is this Mr. Schmidt's client? Robert?
Yes, Judge.
All right,
Yes, Judge.
all right. Has Mr. Bates consented to you arguing his writ today?
Do you mind if I argue a bit for you? He's fine with that, Judge.
Okay, court calls WR 23-3. Robert Earl Bates versus State of Texas. Are you going to be calling Mr. Bates for purposes of the hearing today?
Judge, not at this time. As I said with Mr. Carter, the state and the defense reached an agreement. In this case, it was for a reduction for a $10,000 cash or surety bond. And Mr. Schmidt outlines the reasons that his client is entitled to that, the reasons that was agreed to in his writ. And so I'd rest on that. I also know that the state offered, without objection, the PC affidavit and has provided that to the court and to the defense.
Anything from the state?
Your Honor, Mr. Schmidt came to me before he left to go out of town, and he told me some extraneous information surrounding the events that are contained within the PC affidavit. He did not ask for a PR bond, but did ask for a bond reduction. Given the extraneous information, I felt like that was fair. We don't have a case. I've presented to the court all that we have in our file. Additionally, I don't have a criminal history. However, what was relayed to me from Mr. Schmidt was that essentially his client has contacts with the area. I believe he lives in Shreveport, but I believe he travels this way a lot. And that essentially the events of that day were a panic response to some extraneous factors. So we felt that the reduction to $10,000 bond based on his proximity to the court, even though it's out of state, and that extra information was a fair and reasonable reduction.
And I can add to that in speaking to Mr. Bates today, he has informed me that he will be living in Dallas and he will be able to abide by any and all conditions set by the court upon release on the agreed bail.
Ms. Heisel, is the extraneous information something I can be privy to? And because what I'm seeing here is 120 miles an hour, fleeing from the police and wanted in other areas, wanted in other states.
Your Honor, if you'll, that's the reading I took of the PC affidavit at first too, but I do believe that it was not Mr. Bates who had the warrant. I believe that it was his girlfriend who was the passenger in the vehicle, and that is the extraneous information. I believe that they were aware that she had a warrant. Also, there is mention of the vehicle being reported as stolen. There are no charges that I'm aware of right now for that. And Mr. Schmidt gave me some additional information on kind of backstory on that as well. I'm not saying it's justified. I'm not saying we're not going to proceed in charges. I'm just saying, the information Mr. Schmidt provided me was this was a panic response, and, there's no, I don't believe, flight risk for Mr. Bates in this case.
Okay. Anything further, Mr. Manning?
Nothing from defense.
All right, court will take it under advisement until the conclusion of the docket today, and then I'll issue an order.
Yes, Judge. Judge, the last one I have in here is Mr. Lyons.
All right, Mr. Lyons, if you'll come forward, sir. This is CR 22-152, CR 22-276, State versus Takitian Lyons. Is Mr. Lyons a plea today?
Judge, that was the plan. At our final docket call last week, I spoke to Mr. Lyons and he indicated that he was going to accept the offer from the state of 6 years TDC. However, I received a phone call earlier this week that he wanted to discuss some things further. I met with him this afternoon over the lunch break to discuss those issues. I would like to call my client in just a moment to get some testimony, but we've discussed, and at this time he is choosing to reject the state's offer of 6 years TDC and request to go open to the jury on the newly filed charge of unlawful possession of a firearm by a felon.
Okay. Do you want to call your client?
Yes, please.
Mr. Lyons, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. Go ahead, Mr. Manning.
Mr. Lyons, without going into attorney-client privileged information, we have discussed all of your 10 cases over the course of quite a bit of time that you've been here in Van Zandt County Jail. Is that correct?
Yes, sir.
Okay, and we've discussed defenses and problems with most, if not all, of your cases that are alleged against you at this time. Is that correct?
Yes, sir.
And additionally, I've received bonds on 7 or 8 of your 10 cases for you to have bonds on all of those cases. Is that correct?
Yes, sir.
Okay. And we have gone back and forth and negotiated with the state to get you to this offer of the 6 years TC on the unlawful possession of firearm by a felon. And that was the offer that was conveyed to you as being the state's best offer. Is that correct?
Yes, sir.
Okay. And I advised you through explaining my reading of the facts, looking at the law, answering questions that you had, as well as the agreed suppression of your statements on this case, that 6 years TDC would be an offer that should be taken, and you have chosen to still deny and disregard my advice, but go forward and you want to proceed to the jury. Is that correct?
Yes.
And you wish to plead guilty to those charges, but you wish to have them assess your punishment. Is that correct?
Yes, sir.
And
Mr. Manning. Udo, I'm in criminal court right now.
Well aware of that.
All right, well, I need you.
I couldn't find it.
I understand. Thank you, sir. Go ahead, Mr. Manning.
and we've discussed the potential benefits and dangers of going to a jury with the charges that you have against you. Is that okay? And while we may disagree, I've told you that I'm your attorney. I'm going to assist you in the ways that you have requested. And so you requested that it is your wish that we go open to a jury on your charge of unlawful possession of a firearm by a felon.
Yes, sir.
Okay. And you understand that the state's going to file an enhancement to take that, what's a third degree felony, and raise that to a second degree felony with a range of punishment of 2 years up to 20 years.
Yes, sir.
And we discussed all issues that go along with parole and the expanded range of punishment, and you wish to continue on this path.
Yes, sir.
I have no further questions.
Okay. And so you said that he wants to plead open to a new charge. What's the state's position on all of his charges? Is that an agreement that the state?
Judge, the state would agree to allow Mr. Lyons to go open to a jury on again, filed by information. So we would need to make sure that he has formally waived the grand jury process, although I could just take him to the grand jury at the end of next week and resolve that. It's however Mr. Manning and Mr. Lyons would like to do that, but we would be willing to allow him to go open to a jury on that 2 to 20 range, and basically argue all the concurrent charges in punishment and allow the jury to assess punishment on that 2 to 20 range. State believes that would be in the interest of justice.
And the new charge that's filed by information is what offense?
Felon in possession of a firearm, underlying offense. There are 2 concurrent, so there is a underlying felony, and there will be an enhancement paragraph that I will file by a Brooks notice shortly, in anticipation of moving forward on a open plea.
And you said that would the third degree, the second degree, 2 to 20.
Yes, Your Honor.
Okay. And so do we have the paperwork for Mr. Lyons to he's pleading open, he's going to plead guilty to the jury? Is he going to plead guilty to the court and then requesting the jury assess punishment? What's the plan, Mr. Manning?
Judge, typically what I have my clients do in this type of situation is I've had them plead guilty at the trial, and then that guilty presentation be brought to the jury before proceeding into the punishment phase. If the court would like to do something different, I'm open to suggestions, but I have done this previously over in Conklin County, and the way we proceeded was we had him plead guilty at trial. That guilty plea was presented to the jury, and then the jury assessed punishment.
All right, so there was no paperwork to.
Judge, we were anticipating a plea up until Mr. Manning contacted me about 12:15 today, so we did not have a chance to do any paperwork. It was the state's understanding up until that phone call that Mr. Lyons is going to be accepting our offer of 6. And then he has changed his mind, which is his right, but we did not have time to do paperwork.
That's fine. So what I'll do, I'll follow Mr. Manning's advice, and we'll just place him on the jury selection docket. And when his turn is up, then he can either elect to plead guilty or not guilty at that time.
Yes, Judge.
And then if Mr. Lyons does intend to plead guilty, then if just a little notice to both the state and the court ahead of time. At state, it really puts you in the position where you may or may not be able to prove your case. If he decides he wants to plead not guilty the day of trial, then you may be faced with a difficult burden of subpoena witnesses that you didn't anticipate. So
Yes, Your Honor. To combat that, we do still have the burglary of a habitation that is also currently indicted as well. I think it would be inadvisable for Mr. Lyons to do that, but obviously he can make his own decisions on that. But we do have certain recourses should we have to go down those roads, which we do not want to have to do, but we can if we do need to.
okay, just so the state's aware and they're comfortable with how we're going to proceed. All right, the court will place Mr. Lyons on the court's rolling trial docket. And we will begin that on January 30th. And then once Mr. Lyons gets to the top 10, then you'll also be noticed of that, Mr. Manning.
Yes, Judge.
And the court will note Mr. Lyons' rejection of the state's offer.
Judge, could I ask that the court admonish Mr. Lyons as to the grand jury process in regards to this new case, considering it was filed by information, because we had an agreement and we still have an agreement to move forward on that, but as long as we have him admonished and he waives the grand jury process on the record. Or if the court would rather, I can just take it to the grand jury. However, the court and Mr. Manning would prefer that we do that.
I would, well, I was
If
gonna say, Mr. Woodwhite, Mr. Woodwhite, just go ahead and take him to the grand jury. And that way, there's no question about whether or not he's received due process, and there'd be no hangups if a mind was changed later, and there would be no unnecessary delays.
Yes, Judge.
I'm sorry to cut you off, Mr. Manning.
Well, Judge, I was just gonna see, I was handed some plea paperwork and for Mr. Lyons, it seems to include a waiver of indictment. If the court wants, we can execute that just to save time and paper.
Does Mr. Lyons want to do that?
If I may, I just have a moment.
Yes, go ahead. And while Mr. Manning is talking with Mr. Lyons, we have our separate document that's waiver of indictment, correct? And I'm trying to recall in that waiver if there's, my concern with the plea papers that's going to have a waiver indictment is it's also, connected to a plea of guilty and other waivers. We have our separate form that's waiver of indictment and authorizing permission to go forward on the information. How hard would that be to send over to the jail if he wanted to waive his right under that, or if I wanted him to waive his right under that separate order?
I'm not sure who's at the jail who can print right now, Your Honor, but we could get it figured out shortly.
Judge, if Mr. Woodwhite is going to go ahead and present it to the grand jury with the enhancements, then we're fine with just waiting on that.
I will take it to the grand jury. That'll be next week, and we can move forward in that manner.
Okay. And once that's indicted, then we'll have Mr. Lyons arraigned on that charge, and then we'll get it scheduled with these other two. So, okay. All right. So once that's filed, we get notice, and we'll set Mr. Lyons for arraignment, and we'll come back and we'll visit on that issue.
And
That
Judge,
works for the state, Your Honor.
for the jury selection docket for jail, what time am I going to be putting?
You can just put 8:30.
So this is saying I'm come back for the selection on January 3rd. I will not be here for the jury selection. Top 10. Let's go to the top 10. And I will have our trial. May Mr. Lyons be excused?
Yes, thank you, Mr. Lyons.
Judge, I'm ready on Ms. Smith.
All right. Jacqueline Smith. CR 23-00003. And this is a plea today, is that correct?
Yes, Judge. We have executed a waiver of indictment. And whenever the court's ready, we have the terms of the agreement.
Yeah, go ahead.
Ms. Smith is going to be proceeding under an attempted harassment of a public servant by information. Alleged date of that was November 15th, 2022. We're proceeding under 1244A with a plea of guilty, punishment assessed at 51 days in county jail, credit for time served, and a fine of $500. In addition, there is court costs in the amount of $209 and reimbursement in the amount of $515. I've explained to Ms. Smith the process for taking care of her financial responsibilities, and she understands what's required of her once she's released on these charges.
All right, thank you, Mr. Manning. All right, Ms. Smith, if you'll raise your right hand, I'm going to place you under oath. Ms. Smith, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, you are Jacqueline Smith, correct?
Yes, sir.
And Ms. Smith, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me about that?
It's manic bipolar and PTSD.
Are you currently on medications or undergoing doctor's care for that?
Yeah, doctor's care.
Okay. And do you feel like you have a rational understanding of what's going on here today in this case?
Yes, sir.
And are you pleased with your lawyer, Mr. Manning?
Mhm.
Yeah, you have to answer yes or no for me.
Yes,
Okay. And do you feel like you've had enough time to talk with him about your case so that you've had all your legal questions answered?
yes, sir.
Is there anything about the paperwork that you've read and signed today that you don't understand?
No.
All right, Mr. Manning, you've explained the paperwork to your client. Do you believe that she understands the plea agreement and the waivers of the rights that she's making therein?
I do, Judge.
All right, Ms. Smith, you are charged by information with a state jail felony offense of harassment of a public servant, attempted harassment of a public servant. And what a plea to an information means, Ms. Smith, is that you are waiving your right to an indictment. Do you understand that all individuals such as yourself that are accused of felony offenses have a constitutional right to have their case presented to the Van Zandt County grand jury for them to determine whether or not they think there's enough evidence to go forward with your case? Do you understand you have that right?
Yes, sir.
And you understand that the state of Texas could not prosecute you for this offense unless the case went to the grand jury and the grand jury found that there was probable cause and issued an indictment in your case. Do you understand that?
Yes,
And because that is your right, it's also a right that you can waive and allow them to prosecute you on an information. You understand that?
yes,
And that's what you're wanting to do in this case. Is that correct?
yes, sir.
And Ms. Smith, has anyone threatened you, forced you, made you feel like you had to waive your right to indictment in this case?
No,
Okay. Court will approve the waiver of indictment, finds that Ms. Smith has entered into it intentionally, knowingly, and voluntarily. And Ms. Smith, you understand that the range of punishment for this charge, as it's prosecuted under 1244A, is a maximum up to 365 days in the county jail and a fine of not more than $4,000. You understand the range of punishment, meaning that any sentence or plea agreement has to fall within those terms. You understand that?
yes, I understand.
And you heard what Mr. Manning said the agreement was in your case. Is that your understanding?
Yes,
All right, then understanding the plea agreement, understanding the waiver of indictment process, understanding the range of punishment, then Ms. Smith, how do you plead to attempted harassment of a public servant under section 1244A?
guilty.
And Ms. Smith, are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes,
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to states one.
That states one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, in regards to, I don't believe that harassment of a public servant requires victim notification, but I have spoken with Constable Cochran, who is the victim in this charge, and he is supportive of our resolution to this charge.
Thank you, Mr. Woodwhite. The court does appreciate that. Anything further, Mr. Manning?
Nothing from defense, Judge.
All right, and Mr. Woodwhite, can you give me the facts to support the plea?
Yes, Your Honor, on the date in question, the Van Zandt County Constable Jeffrey Coffrin responds to a female who is banging on a homeowner's door, trying to get in the residence out of the rain. He arrives on scene and the defendant is in the middle of the road. It is raining heavily, and her first response is you are going to kill me, speaking to the police. He notes that she is heavily intoxicated. They try to detain her and she resists, not really fighting with the officers, but just basically swinging her arms around, just trying to, I believe in her mind, protect herself. Once they get her into custody, she does spit at the officer. I do believe it does strike him. And she is taken into custody and then taken to the Greenville mental hospital.
Thank you, Mr. Davis. Mr. Manning.
Judge, just a correction, it was actually taken to Hunt Regional Medical Facility, where she was treated for high levels of methamphetamines in her system, which is what led to her unusual and inappropriate actions.
Thank you, Mr. Manning. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Ms. Smith of this offense. Court will follow the plea agreement in this case. The court convicts Jacqueline Smith of attempted harassment of a public servant. Court approves the prosecution under section 1244A of the Texas Penal Code. Court assesses punishment pursuant to the plea agreement at 51 days confinement in the Van Zandt County Jail. Court will award Ms. Smith 51 days credit for the time already served. Court orders her to pay a $500 fine, $290 court cost, and $515 in reimbursement fees. Ms. Smith, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I want you to follow the advice that Mr. Manning gave you with regards to your financial obligations. So when you get out of jail, you need to make sure, Ms. Smith, I'm talking to you. When you get out of jail, you need to make sure that you pay your fines and court costs. You can't pay them all at once. Then you need to make out a payment plan so that we can collect those so you can avoid going back to jail. Okay.
Yes.
All right. Go see Deputy Everett and get your fingerprint.
And Judge, I believe Mr. McKibben is waiting out in the lobby, so I'm gonna go out there, get his paperwork done, and I'll be right back in.
Thank you, sir. I'm going to attempt to bring Mr. Adams in. Do we have Mr. Adams' client? Yeah, Josie Bohannon. Is Ms. Bohannon in the courtroom? Come on up. Come on up, Ms. Bohannon. I'm going to bring Mr. Adams in. All right, good afternoon, Mr. Adams.
Hello, Your Honor.
Are you okay? Do we need to send someone to your office? Raise your hand if you need help.
Depends on who you said.
All right, court calls CR 22-2, State of Texas versus Josie Cheyenne Bohannon. Ms. Bohannon, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can lower your hand. All right, Ms. Bohannon, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
No, Your Honor.
And in this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with Mr. Adams' representation of you?
Yes, Your Honor.
And is there anything that about the paperwork that you've read over and signed that you do not understand?
No, Your Honor.
And when you did sign the paperwork, you're swearing that is your true and correct signature, and you only signed once you were satisfied you understood what you were signing, correct?
Yes, Your Honor.
All right. And Mr. Adams, do you believe Ms. Bohannon to be competent today?
Yes, Your Honor. She's mentally competent.
And you explained to her her rights as they pertain to this case?
That's correct, Your Honor. I have.
You believe that she understands everything about this agreement today?
That's correct, Your Honor. She understands everything.
All right. Ms. Bohannon, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. That does carry a range of punishment of not less than 6 months in state jail, TDCJ, and not more than 2 years. And an optional fine not to exceed $10,000. I see the plea agreement in your case is that you would plead guilty to that crime in exchange for the state's recommendation that your sentence be assessed at 6 months, the minimum, in state jail with a 0 fine plus court costs, reimbursement fees, and restitution. Is that your understanding of the plea agreement?
Yes, Your Honor.
All right, Ms. Bohannon, then I'm going to ask you at this time, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime for no other reason?
Yes, Your Honor.
All right, court accepts the defendant's plea of guilt. Mr. Adams, any objection to state's evidence?
No objection, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we'd rest to close at this time.
From the defense?
Only, Your Honor, that Ms. Bohannon and I have talked about the possibility that she may have to be transferred to a state jail facility in order for her to obtain a TDC number. I could not guarantee her one way or the other that she would or would not, but she understands that's a possibility. And in any event, there was a blue warrant out of Smith County for her, such that when she does leave Van Zandt County and or a state jail facility, she will likely be transported to the Smith County Jail to take care of her business here.
Yes, and Ms. Bohannon, last week when you were unable to make it and you were ill, she brought that to my attention when I was trying to, Mr. Woodwike and I were discussing, trying to figure out how would TDCJ treat her, release her from here, make her come down. And while we were trying to figure all that out, Ms. Bohannon brought that to our attention to let us know that she was going to go elsewhere to kind of give us an answer. So I told her I appreciated that information that day. So thank you again for putting that on the record. All right. Court's going to review the evidence briefly. And state, is there a live report in this case?
I believe so, Judge. Let me see if I can pull it up. Yes, Your Honor, there is. If you'd allow me to share my, or I could just tell the court, Mr. Adams has this. The lab tested this and confirmed 0.27 grams of methamphetamine. The state would offer State's Exhibit 2. I will add that to the court's record this afternoon if Mr. Adams has no objection.
No objection.
Okay, court will admit State's Exhibit 2, the DPS lab report. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Ms. Bohannon of this offense. Court will follow the plea agreement. Court convicts her of possession of controlled substance in penalty group 1, less than 1 gram, assesses her sentence at 6 months confinement in the Texas Department of Criminal Justice State Jail Division, and orders her to pay $180 restitution, $290 court cost, $85 reimbursement fees, and the court awards Ms. Bohannon 180 days credit towards her 180-day sentence for the time that she has spent in jail on this cause. Ms. Bohannon, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from state jail, wherever that may be, Ms. Bohannon, you're still going to have court costs, restitution, reimbursement fees. Those are going to be required to be paid. So you'll need to contact our court compliance officer and make arrangements to get on a payment plan if you can't pay that in full. Okay.
Yes, Your Honor.
All right, go ahead and step over with Deputy Everett. He's going to take your fingerprint. Is that all you have, Mr. Adams?
That's it, Your Honor. May I be excused?
Yes, you may be. I'm glad to see you're feeling better.
Oh, yes, sir. Thank you.
All right, we'll see you.
See you all soon.
All right, do we have Jesus Gutierrez? CR 250. All right, Mr. Gutierrez, you're in jail on a motion to revoke warrant filed on your underlying charge of aggravated assault with a deadly weapon. Or have you requested a court-appointed attorney? Are you gonna hire an attorney? What's your plan?
I did not get an attorney. I believe Patty Abraham was on my paper though.
Okay, so did you submit paperwork to her requesting an attorney?
No, no, sir.
Okay, so you got to do that. If you want something done, you have to ask for it. Okay, so you'll need to request the court-appointed paperwork, court-appointed attorney paperwork. And if you haven't done that, you'll need to request it, fill it out so that we can review that and determine if you're indigent, then we can appoint you an attorney. If you're not, then we can try to figure out the next step, okay?
Okay, yes, sir.
Judge, I have some paperwork.
Okay, all right, so go ahead and have a seat, take that over there, fill that out, and then we'll call you back up here in a few minutes to try to figure out what we're gonna do. All right, we're gonna stand in recess until Mr. Manning is ready with Mr. McKibben. I think that's all we have is Mr. McKibben and Mr. Gutierrez.
That's what we show, Your Honor.
All right, we'll stand in recess for a few months.
Really hard, huh?
Mr. Manning, are you ready? Can you unmute that, Mr. Manning?
I didn't quite hear what you said, Judge.
I was just asking if you're ready.
Judge, I'm ready on the recently appointed one that I just received, Mr. Gutierrez.
Okay, yeah, Mr. Gutierrez, if you'll come back up. This is CR 2050, State versus Jesus Humberto Gutierrez. Motion to revoke. Mr. Gutierrez has completed the request for court-appointed attorney. The court finds him to be indigent for purposes of counsel and has appointed the Honorable Jonathan Manning to represent Mr. Gutierrez. Mr. Manning, do you want to reset this until the contested docket on February to give you time to become familiar with the case?
Yes, Judge, I was just, right before we got called up, I was going over the motion to revoke with Mr. Gutierrez. And it is the February docket, is that the next docket?
No, the next one would be January 26th.
If I may have just a moment, let me ask Mr. Gutierrez something. Yes. Judge, if we may, maybe give it a shot, set it for this contested hearing. Based on what I reviewed so far, in the motion, I think I should be able to speak to the state and we might have a chance of getting a resolution sooner rather than later.
Okay. All right, the court will set Mr. Gutierrez for contested docket on January 26th. That'll be at 1:30.
This one right here is just saying, come back to the 26th. And hopefully we'll have some options for you at that point.
I'll be sitting here until then.
Yeah, I'm gonna meet with you on Friday. That's our typical day to meet with folks. We'll go over your motion as well as possible mitigation. For that, okay?
Motions for
Your motion to file. So you had a motion to proceed and filed by the state. Says you do what you're supposed to. So I'll work on Friday. Okay.
Thank you. I just need to wait.
Yes, sir.
You ready? Are you ready on Mr. McKibben?
Judge, I just spoke to Mr. McKibben on the phone. And I think I may have misunderstood Deputy Everett's message. It sounds like he is currently walking this way.
It
So
seems vaguely familiar.
I offered to save him some time and steps. I offered to request the DA's office investigator to go pick him up. And he said he'd like to try to get his ride to come pick him up. So I told him court was almost done. And that's about where our conversation ended.
Okay. And what's the plea for Mr. McKibben?
8 months state jail.
Okay. Well, so we don't have any kind of ETA for Mr. McKibben.
No, Judge. I can't honestly say that I could pinpoint his arrival.
Okay. And is he on a surety bond or personal bond? My docket doesn't say.
Judge, I'm not sure. I believe he may be on a PR bond.
Judge, if you give me a chance, I will look it up.
Sure, please.
I believe it was one of those drug cases that the state didn't have a case and we got a 90 days on.
Judge, I show he's on a $10,000 bond with East Texas bail bonds.
Judge, maybe if I could have a couple minutes to
That
contact.
may have been released on the 5th when he was unable to arrive to show up in court. I don't show anything that did that, but I do show on 8/9/2021. There's a surety bond for $10,000 by East Texas bail bonds.
Judge, if I may, maybe contact East Texas and see if they have a way for Mr. McKibben to get here. I don't know what services they offer as a bail bonds company.
Yeah, I think maybe the best thing to do is, I think I had the NISA under advisement until 1:30 today, correct?
Says reset until 1:10, but I don't know a time, Your Honor.
Yeah. And so I didn't do the NISA the other day because Mr. McKibben did appear at the jail and we didn't have the warrant for him to take him into custody. So I think what I would rather do is just find his bond to be insufficient. That way we're not all sitting around waiting for someone who may not appear. So the court will have his name called loudly, distinctly in the Justice Center there, and then in the courthouse here. And if he doesn't appear, then the court will just find his bail to be insufficient rather than a NISA. And then I'll ask the clerks to get the warrant issued and sent out to the jail, and then turn himself in on that warrant.
Yes, Judge.
Okay. All right. And then once Mr. McKibben gets in custody, we'll be notified and then we can set him for plea.
Yes,
That
Judge.
works for the state.
And I see that Mr. Bates is still here. Has the court made a determination on his agreed bond reduction?
No, I haven't. I'll do that as soon as we get through here.
Yes, Judge.
All right. All right. If there's nothing further, then we'll be adjourned.
Thank you, Your Honor.
Thank you, Mr. Woodwright. Thank you, Ms. Heisler.